We are going through a very interesting period of antitrust law because it is changing quite dramatically. The enforcement agencies and the plaintiffs' bar are moving beyond what has governed the last 40 years of antitrust concerns, namely price, number one, output, number two, and quality, number three, to broader issues such as innovation, what's the pace of innovation, social justice and equity issues. So the school of thought that's inhabiting the two antitrust agencies, the Department of Justice and the Federal Trade Commission, populated by what we call neo-Brandesians, they are broadening the constituency of antitrust concerns. And we haven't seen that in 40 years.
It is really an incredibly dynamic time in the antitrust space, and I think that's really driven by a very aggressive approach by the antitrust agencies. They're very enforcement-minded right now, and I think that's really driven by a couple of trends that I've been seeing. The first really is we've been seeing the enforcers dust off tools in their toolbox that they haven't really been using as much in the recent past. I think we've been seeing that in a couple of places. First, in the labor and monopsony space. We've been seeing them bring cases where labor issues or monopsony concerns are really driving the case. The second area where we're seeing that is in interlocking directorates. I think that is a place where it was really a secondary concern. Let's say in a merger investigation, they might uncover an interlock directorate, but now we're really seeing them go out and affirmatively look for those cases specifically about interlocking directorates in a way that they hadn't previously. And I think really the second key part of the change that we've been seeing is in litigation risk. I think the agencies have come out and said they are less concerned about litigation risk than they have in the past. They are not afraid to bring cases when they think there's been a violation. The advice I would give to companies is twofold. I think first, just to be incredibly compliance-minded, to have a robust compliance program, to really remind people that it's important to think through what the antitrust implications might be of something that they want to do. And I think the second piece really would be that they should be aware that the agencies have been branching out and using merger investigations to look for other violations.
In terms of this age of aggressive enforcement by the agencies, the approach companies should take is to stay abreast of statements and speeches given by the leadership of the two agencies, namely the Federal Trade Commission and the Antitrust Division of the Justice Department. And companies should continue to innovate and compete in a hard and pragmatic fashion, but stay abreast of antitrust concerns expressed by the agencies and work hand in glove with antitrust counsel so that you're not competing in a way that the agencies consider to be unfair.